Welcome to Awaken Empowered TV. I'm your host, Ethan Fox. Today I'm joined again by Winston Shrout, who was a guest on my show several months ago. Today we get really in depth into the history of the legal system, the court system, and how it originated, including a lot of the details of how it actually functions today, and as well as some really fascinating stories that'll help you to understand what actually happens when you are called into court or when you get a traffic violation and how to deal with those circumstances within the system as well. So without any further delay, here's Winston Shrout. Hello, Winston. Welcome to Awaken Empowered TV. It's a pleasure to be speaking with you again after the last show. We had a lot of really interesting feedback from the viewers of our show, and I'm excited to be continuing our conversation. And today we're going to be talking a bit about the court systems, and I'd really like to start with the history of the legal system, and then we can lead into the court systems after that. So could you kind of tell us where it all kind of began from your perspective?
Sure. Ever since people have been on the planet, it seems like from time to time, controversies arise, maybe between neighbors, maybe involved in some kind of business, or even in a kingdom situation as they had it in ancient times and so forth. So there had to be some method for dispute resolution to try to bring equity and fairness to all parties. So we've always had courts, perhaps not maybe as formal, some of the ones we have today, or maybe even more formal as the situation may be. But in any event, people have, for whatever reason, can't seem to get along with certain situations, so we have to have some manner to resolve those problems. Now, in our present world, here we are here in 2015, get close to 2016, by the way. In any event, we find ourselves with some of these same problems. But one of the things that has happened, certainly in the last several decades, is that the original designs of the, for instance, the Constitution and some of these things, those original designs have been perverted severely to the point that, to be quite honest, the whole court and justice system has turned into a money-making operation. Now, I'll explain how that worked or has worked, but first, before I go into that phase of it here in 2015, maybe we should go back and see how this has developed. Because, history is an interesting thing, and we've been advised that if we don't study history, that we're likely to repeat it. So we try to learn from the things that have gone on before, and so that necessitates a certain amount of study. And I have studied quite a bit into some of these elements. Actually, when I first started my study of what we call law, or whatever you want to call it, some of the first information that I actually looked into was the ancient, what's known as merchant law. Now, that's an interesting concept. But some of the problems, they perhaps even go back further than that, because what I want to do is give a short history to show how we have come to our civil law, which is the element that most people seem to find themselves involved in. Now, we do have what we call criminal law, but actually, truth be known, the civil and the criminal are actually the same thing, depending on the amount of money involved. So if you're in the small amounts of money and so forth, and we talk about civil, if it gets into larger amounts, then we call it criminal. On this basis, and that is under the statutes of the United States, in particular the Code of Federal Regulations. It has been rewritten in such a way that all crimes are commercial. And when we when we start to think about the term commercial, first thing that pops into people's mind is money. And so as I go along and as I give a little bit of this history, perhaps it will be obvious, what we've come to, which is unfortunate. But anyway, if you go back through the history, particularly of our civil law, you have to look into the histories, basically, of the Vatican, because as it turns out, all of our civil law system is based on canon law. And then you need to look at the history of where the canon law had come from, because it, for the most part, dominates our commercial law system. So when you go back in history, I mean, you had all these European things going on. And, for the most part, most of our system has evolved out of the European system, or what we call the Christian system, because peoples in other places on the planet simply don't carry on their business this way. And so our present legal system is technically based upon Christianity. Now, Christianity is an interesting term. Most people, when you hear the word Christian, they keep thinking about the character 2,000 years ago known as Jesus. And that might be a mistake, because there was no such thing as Christianity until Constantine. Now, Constantine is an interesting character. He became the emperor of the Roman Empire, and his father was Constantinus, and he actually ruled the Roman Empire from England. This Roman Empire is a very interesting study in and of itself. But in any event, the father of Constantine was a man known as Constantinus, but his mother's name, I forgot her English name, but she's known as Helen of the Cross. And she was a devout follower of what was known as the Way, which was based upon the teachings of Jesus and the apostles. So we have a span there of a few centuries until you get down to the time of Constantine, who was having a great deal of problems in his kingdom or in his empire with the various religious factions. And so he had Muslims there, he had followers of the Way, he had the Judaic system. So anyway, it was really a problem because it was dividing the empire. And so to consolidate and make the empire stronger and easier to rule, then he called all of the religious leaders together and said, hey, we're going to sit down and figure this thing out. And so as a result of that, there was an political entity known as Christianity. And so that's actually where Christianity itself started. So that was the Council of Nicaea. I think that was around, about 320. Anyway, in the mid-300s, they were wrestling around with this problem. And as a result of those conventions, they came out with certain definitions about who and what God was and all kinds of things. And this is where the monotheism came into play. And prior to that time, all of these various factions had a pantheon of gods. And so now all of a sudden they said, well, we got to consolidate now. We need to come up with one definition of who God is. And so that's where we get into the monotheism concept. Now that carried on for a while, what we would call the Christian church. And the word church itself is an interesting word. It needs a little bit of study. But it basically, the definition is a called out assembly of people. Okay, so it's not an organization, it's a community, it's a group of people, which puts the whole thing into reality. And then we've kind of, the word church has kind of evolved. Most people think of a building, or they might think of an institution, so forth. But in any event, as a result of the efforts of Constantine, they created the Christian church. Now that went on for a few centuries, and then there was a certain concern that decided that needed to change things a little bit. They had more of a overreaching thought process, and so at that point, then they created the Catholic Church. Now, the word Catholic refers to the word universal or worldwide. And so the concept that they were trying to express was that whatever doctrine or dogma or so forth that they had created should, in fact, become the worldwide religion. So there was a great deal of effort made to do that. One of the things that actually happened with that situation was they created something that was known as the doctrine of infallibility. In other words, the leader of this new organization, this new church, the Catholic Church, set up the individual who was in charge of that whole operation as being infallible. In other words, he could do no wrong. Whatever he said was exactly right, and no one could challenge those decisions. And so for that time, you had kind of what is papal bulls and all kinds of things that came out of that. But this whole concept was based upon a document that was known as the Donation of Constantine. Which was later, of course, proven to be a complete forgery and a fraud. But anyway, based upon that, some of those documents and so forth, they created that doctrine of infallibility. Now, the effort at that time, which would be around, let's say, about 750 AD, there were certain battles raging in Europe. The predominant ruling body was what we refer to as the Merovingians. And the Merovingians are an interesting group. They had, when you start to talk about the Merovingians, you're also talking about the Fisher Kings, basically of Gaul or France, certainly who had descended from the combination of Jesus and Mary Magdalene. And so those children, of course, kept going and so forth. And as a result of that, we had the Merovingian dynasty. Now, it's kind of interesting. I think a lot of people have seen that movie, The Da Vinci Code. And they certainly claimed that the Magdalene had one daughter. but it appears that's not the case. It appears that she had a few children, at least 3. And so there was, anyway, as a result of that lineage, there was a dynasty of kings and so forth in France. So there was a little bit of war going on. Charles Martel and his children, his sons and so forth, set up certain things. They changed over the kingdom from the system of kings into the system of mayors. Now, these mayors were known as the Carolingians, and certainly they were in close association with what we call today the Vatican. So we have this joining, certainly, of church and state that everybody complains about during that period of time. Well, this organization, as we call it, Catholic organization, continued for about another, let's say, 300 years, until eventually that system was basically taken over by the what's called the Romans, or what a lot of people refer to it as the Roman cult. And the reason they call it the Roman cult was due to the introduction into the Christianity / Catholicism of paganism. And so many of those elements of paganism were introduced into the church at that time. And so you kind of get in a crazy mishmash of things going on here. But the key element is that the church, as it was conceived of, was basically in control of the whole situation. And so as a result of certain things, certainly as they went on in time, we had some other elements that occurred in, let's see, it was, well, if you go back to William the Conqueror, who conquered England, except for the city of London, and that might be an interesting study in and of itself, but in any event, between William the Conqueror and King John, basically the kingdom went bankrupt. And I don't want to go into the reasons for that. We don't have time for it. But based on certain economic and commercial practices, the kingdom went bankrupt. And so it put King John into a pretty bad place to maintain the kingdom. And in consequence of that, he passed a law that no one could transfer property either to another private individual or to the church without the king's approval. Well, this got the boys down in Rome just a little bit excited there because now all of a sudden the people could not give property to the church. And so in consequence of that, the Pope excommunicated King John to get him in line. And for whatever reason, whatever conscious reason King John acted, he decided he needed to get back square with the church because I guess he was afraid of losing his eternal soul. So, in essence, then he acquiesced to the situation there. So in 1213, in essence, he turned over the kingdom to the Pope. Now that made the Knights Templars pretty upset. As I mentioned, when William the Conqueror came, he was able to conquer the whole kingdom, except for the city of London, which was held by the merchants. And the merchants got into a treaty with William on the basis that they would maintain their own merchant law in exclusion of any other law in the kingdom. So that's where we have the continuation of what's known as merchant law, which of course is substantive law. Okay. But anyway, in consequence of what happened there, like I mentioned, the Knights Templars got pretty upset with John, so they had a little bit of a talk with him. And so in 1215 was when we had the production of what's known as the Magna Carta. And folks need to look into that and study it. A lot of good history just in the concepts that are there. But in any event, the Pope's representative in England, in the kingdom, was actually the Archbishop of Canterbury. So it's an interesting history. And then in the 1400s and in the 1500s, the Vatican set up certain trusts. The first trust they set up was in, looks like 1455. It was a testamentary trust that was created to hold the land in trust, a certain amount of perpetuity and using trust and so forth. So at that point, they were claiming in this trust basically the whole planet without consulting other peoples and other places. But anyway, egos are going wild now. So anyway, they set up this trust. And then in 1481, they created yet another trust where they claimed the people on the basis that the people had simply come up out of the dirt. And so they said, well, if you came from the dirt that we own, therefore that we own the people. As silly as that might sound. But they were serious about it. And then the guy went even further yet. In 1537, excuse me. 1537, there was yet another trust set up, which was not a testamentary trust. It was actually what we would call a sestque vi trust. And we could go into that a little bit. But anyway, in essence, what they were doing was claiming that since the Pope was considered the vicar of Christ, and since the Pope was capable of forgiving sins, that created a liability. And in consequence of that, then this particular trust tried to demonstrate that they had a lien on the soul. So the soul's in the body came out of the dirt, and so all these crazy connections were conceived of. To any thinking person, that's all completely ridiculous, but that's the way they operated. Now, in consequence of these things, we had other things that came down, but in essence, the reason I'm going over this history is to show how we have come down to our present thought process, certainly with our civil law, because again, all of our civil law is based on canon law. The canon law came from the sedis seclorum that was established, the papal bulls and all those kind of things. And so here we are in 2015 operating on concepts that were developed through this history as I've just described here. Now, is that what the people want? Well, some do, and perhaps others don't. But by, how shall I say, force and extortion, our present justice system has been set up in this manner to the point. I think most people are cognizant or have a little bit of history on, for instance, the Constitution for the United States of America, which in fact described 3 separate jurisdictions for dispute resolution in the form of the common law, the equity, and the admiralty law. Now, those are the 3 basic law jurisdictions and forums that were established by the thinkers back in the days when the Constitution was formulated. And then as you get down through the ages here in the, let's see, somewhere in the 1960s, and I can't remember, at some point they had combined the common law with equity law. And then at some point they combined admiralty with that. And then it came up with one system of procedures to accommodate all 3 of those law forms, which is known as the Federal Rules of Civil Procedure. And so regardless of whether your claim is in the law, if your claim is in the equity, if your claim is in the admiralty, in order to get those remedies, you would have to use the Federal Rules of Civil Procedure, which of course has been codified in all the state civil procedures, probably word for word. So again, we're right down to the point now where we're operating totally with civil law. And as I mentioned, the history of it, where it came from. Now, are those the things that people want? I don't know. I haven't taken a poll, but I think most people are stuck in those things and don't know how to get out of them. And so that's basically what I've, been doing, is teaching people these things. Do you have any questions on that? Just a little bit of, just a bare bit of history there?
Yeah, well, it seems like a lot of things changed in the 1930s, especially in the United States. So what are some of the things that happened in the 1930s and since then that altered that, or in terms of historical value?
Well, I think really it relates to a particular Code of Federal Regulations. It's, 27 Code of Federal Regulations, 7211, whereas they described all crimes as commercial crimes. We're talking about burglary, theft, assault and battery, rape, and murder are listed as commercial crimes. Now, why in somebody's mind and thinking, why would they list a physical injury such as murder as a crime? And the reason is because whoever did the murder was depriving the state of its property. Now, when you start talking about how this all came about, certainly we need to go back and review the events around 1920. Prior to that time, there was no such thing as a birth certificate. And in consequence of that, around that period of time, there's a great deal of social concern about the way children were being treated. And they were being treated poorly. In some of the manufacturing areas, children were involved in slave labor, just like it's happening in some of the third world countries today. So anyway, the public outcry was against the misuse of children. But then the question got to be is, how can we as a government have jurisdiction over the children? And in order to accomplish that, they set up a system that we today refer to as the birth certificate system, whereas the children were registered so that the government could have jurisdiction and to prosecute those who were misusing children. From a purely philosophical or a moral point of view, that was a good thing. I mean, I don't think anybody would have any kind of qualms at all about what was done for that purpose. The question got to be, though, to what extent would the state take that control? And so over the period of years, certainly since the 1930s and so forth, when a certain system was devised, and I'll go back over that just in a second. But anyway, the extent that the whole thing has taken over a period of several decades, right down to our present day, is that now the government says to parents, you will vaccinate your children whether you like it or not. I was a victim of that. I was a victim as a young person, 6 or 7 or 8 years old. I was victimized by inoculations. And that was, at that time, there was supposedly an epidemic of polio. And in consequence of that, there were vaccines which were created, at least at the very start, whereas children were inoculated with this polio serum vaccine or whatever, which, on the surface doesn't sound too bad, with this exception that in recent years they've gone back and done testing on that polio vaccine and found cancer virus in it. Now, that's one of the main reasons why people, baby boomers like myself, are coming down with cancer at alarming rates. But it was because of that forced vaccination. We could not avoid it, as it appears. Now, in more recent times, I think parents are finally savvy to what's going on with some of these vaccinations. And in consequence of that, there's quite a public uproar. And so then the individual parents are having to butt heads with the government over it. And so certainly the technologies and so forth that we are developing and have developed and so forth would prevent the intrusion into the lives of the families with children on this inoculation issue. Perhaps we can talk a little bit about that toward the end. But in any event, again, the events around 1933 are important to consider because of the changeover in money. And I think we may have talked about that a little bit last time we had an interview. But what we're doing, in essence, then, is we're changing the form of money to fictional money in the forms of negotiable instruments. And now we're to the point that all our money is computerized. And so the money we think we have is actually just numbers on a computer screen. So, what does all that lead to? I will say that if things were properly handled, without the intrusion of those who have it in their mind to cause problems, I believe the system would work very, very well. However, because of the, how shall I say, evil intents of some, then we have gotten into some serious problems on the money issue because of the control that the banks, the government, and so forth have over the assets of the people. Now, during that period of time, we were actually going into a third period of national bankruptcy. And in consequence of that, the pledge system was set up, all kinds of things. We don't really have time to go into that so much, but just to say that because of the change in the monetary system and how commerce functioned, it allowed certain factions to take control and basically just wear the people out with all this foolishness. Now, our subject today really has to do with the court system, because it's the court system that enforces the policies, the monetary policies and so forth, most of which, of course, become corrupted. And so now we have a problem, not just with the monetary system itself, but then we find ourselves faced with the inability to deal with the court system, who have access to the police, who carry guns and clubs. So now we're getting into some issues where the civil matters are being enforced by people who have guns. And it's got, as you know, certainly anybody that watches the news for very long will come to the conclusion that we have many, many problems in that respect. So perhaps we can talk about the thought process of courts for just a little bit. I wanted to go into, for people's information, perhaps I haven't been exposed to some of this thought process, but I certainly wanted to go into the how the courts make money, because they make a lot of money.
Before we do that, I want to, last time we talked, you mentioned how Hitler was connected to the Secret Service and Nixon, and I thought it was very informative and interesting connection. So could you share that whole line of thought before we head into the court systems?
All righty. Yeah, the acronym SS originally stood for the sedis seclorum, which is the Latin word. Anyway, it was the system of law. What I didn't mention in my history was the formation of the Jesuit order in 1540, who became the soldiers of God, as they supposed. And certainly there's a certain amount of interrelation with the Swiss Guard and so forth. But in any event, this SS is a very interesting acronym, as it was originally, I think it was the Holy See from 748 AD. Yeah, about the same time when the Christian church turned into a worldwide Catholic church, through the donation of Constantine. Then the Sedis Seclorum, or the SS acronym, appeared then. And then as we start to trace the concept, we get down into Nazi Germany. And so we have a separate organization apart from the German government, which was known as the Nazi SS. And it's from my calculations of history, it appears that this SS is simply a continuation of that original SS. And then we don't need to dwell on the terrible things that was carried on by the Nazi SS, but then a lot of people certainly are aware that after World War II, many of the Nazis were brought to the United States, and they infiltrated everything as it appears, the financial systems, the government, everything, until eventually we have something known as the Secret Service, SS. So it makes someone, kind of suspicious that there's some kind of thing going on here. For example, I have matter of fact, I still have him as a friend. It's been a long time since I've seen him, but he worked for the Secret Service. And he said that his job, he was right next to President Nixon. And he said he put him to bed every night, just drunk off his feet. And my thought process was, oh, geez, here it is, the guy that has his finger on the button to start a nuclear war, and the guy's drunk all the time. Now, that's not very encouraging. However, what he did tell me, so in connection with his duties as the bodyguard, as it were, for President Nixon, I asked him, basically I was putting the question to him, so what was it like to protect the president? And he said, oh, no. He said, you got it wrong. I said, really? He said, yeah. He said, I was not there to protect the president. He said, I was there to protect the system. He said, if my immediate supervisor had told me to draw my pistol and kill the president, he said, I would not have hesitated. Now, that's kind of a scary thought, especially when you get back to the assassination of John F. Kennedy. I think everybody in the country now is pretty much aware of the Secret Service. Certainly, for the most part, they were told to stand down, and then the fatal shot that actually blew off Kennedy's head was a Secret Service driver. I mean, I don't think anybody in the country that's looked into any of this at all has failed to see that. And so again, what this fellow told me about if his immediate supervisor had told him to pull his gun and kill the president, he said he would not have hesitated. And so what kind of a group or what kind of an organization has that kind of power? And certainly it's frightening when you consider it in that respect. So I cannot do a complete correlation between our Secret Service today all the way back to 748 with the sedis decorum, but there seems to be an underlying theme going on there because of the consequences of their actions. So is that kind of what you had in mind?
Yeah, definitely. Yeah. So anyway, carry on what you were, with regard to the Jesuits. You didn't touch on that too much, so if there's more you can share. And, when I spoke with Keith Scott, he said something interesting. He said that the Queen of England was a fief to the Vatican.
Correct. Again, going back to the agreements between King John and the Pope, then every succeeding royalty in England and so forth would be under the same responsibility or under the same treaties and so forth. So there is a close connection between Queen Elizabeth and the Vatican as it was. However, for those who are keeping close track of current events to see the actions of Pope Francis, we're starting to see a bright light shining through the clouds. I'll put it that way. I'm very interested to follow his career. He's making all the right moves. I'm not trying to be political one way or the other with some of these things, but people ought to watch the actions of Francis. And just let me say, as a non-Catholic, I'm very encouraged, very much so encouraged by the actions of Pope Francis. So keep your eye on him. I think that'd be a good thing to watch.
Okay, so let's talk about the court systems and how the historical information you just shared evolved into what we have today.
Yeah. As I mentioned with the Code of Federal Regulations 277211, where it classified all crimes as being commercial crimes, then you start to talk about money. So we're not talking about justice, we're talking about accounting to determine the resolution to problems that we would call crimes. And so in times past, for instance, if someone murdered someone, they would either put them in prison for the rest of their life or hang them. So that was real justice. But in today's world, they have, since determined that all crimes are commercial, then the resolution to these crimes, as it were, is payment of money. Now, this comes in several it comes from several different directions. Let me just hear my notes. Point out, it must be here. Sorry. Yeah. First, let me say that the system of statutes and codes that we have, which are based upon commercial crimes and so forth, you'll notice that all of them have a penal sum attached. Now, this kind of goes back, this has the same flavor of what Martin Luther was fighting against with his 95 Thesis, and that was what he called paid indulgences, where if someone committed a sin or a crime, as it were, then they could pay a monetary value on that particular sin, and then it would be forgiven. Okay, so we kind of have that history, and that's some of the things that Martin Luther certainly is protesting against. Now we come out of our modern times, and we find that our state and federal statutes have a penal sum attached. Now, for instance, your state statutes are valued at $100,000 per charge, and your federal statutes are valued at $250,000 per charge. Now, you can't find this on the internet. You have to go to your law library and actually get out a hard copy. But with each statute, it will list on it the penal sum that is attached to the violation of that particular statute. And you can actually, if you have the money or other devices, perhaps, that we might talk about, but if you have the money and you go commit a crime, you can simply pay your way out of the charge. For instance, I had a fellow one time called me up, and I think he's down in Florida, and he had 5 federal charges against him, of course, valued at $250,000 per charge, for a sum total of $1.25 million. So he went to the prosecutor, said, how can I get away from this? What do I have to pay to get away from this? And the prosecutor came right back and said, it's going to cost you $1.25 million. And he says, as a matter of fact, I'll take it over 5 years. You can pay me $250,000 per year. I don't even know what the charges were, but the point is, it's the same thing. That if you have money, you can pay your way out of any crime, including murder. Now, how does that sit? I mean, where do you find any kind of justice in that? And so the question gets to be, where does the money go? This $250,000 per charge, you see. So we're not really quite sure where it goes. We really can't get inside the court system to audit their books and so forth. And there's a reason for that. There's a reason why you can't audit. And let me just give this to you so people will be aware. First off, let me explain that our court system, both state and federal, is not tax supported. These are all private enterprises masquerading as the historic court system. Now, the easiest way I found it out was that, for instance, I was living in a certain area in Utah. And so the local court was called the 5th District Court. And so I went to Dun & Bradstreet. You know, Dun & Bradstreet is the reporting agency for all the corporations and so forth. So I went looking for the 5th District Court on Dun & Bradstreet and couldn't find it. But what I did find was a corporation known as the Justice Courts of the state of Utah, in all capital letters. And then it showed the places where they were doing business. And the places they were doing business was exactly where the courthouses were for the 5th District, the 4th District, the 3rd District, and all up the line. So I knew that I had found the corporation that was running the court system. And then I took it another step further. And that was, I did some research with the Utah Secretary of State office, because that's where corporations are typically registered in the state to do business. And guess what? The justice courts of the state of Utah were not registered to do business as a corporation with the Secretary of State, which means that they're private corporations. They're not registered, and they do not pay taxes as a corporation. Now, how did they get to do that? I mean, I think all of us would like to be able to do that now, wouldn't we? Well, somehow or the other, they wrangle that thing around. So what people are calling your state, even the federal, are actually corporations doing business as private corporations, not taxpayer supported. And in consequence of that, the taxpayers have absolutely no say in what goes on there. You can't audit them. Now, if you go to your city and so forth, look at the court buildings. Go inside the things. For instance, one time I was in Las Vegas doing a little bit of a few things with some of the U.S. Marshals, or I've tried to do some things with some of the U.S. Marshals, and they got upset with me. And they threw me out of the building based on no trespassing. Now, what does that mean? Are you trying to tell me that a taxpayer can't go into a tax-supported building and talk to the people there? They threw me out of the building, said, don't come back here on the basis of no trespassing. That indicated that that courthouse was, in fact, private property. So when you have these little experiences from time to time, it kind of gives you the idea that things are presently not like they were some time ago. Now, when all these things changed, I can't really say. I don't know. Was it over a period of time? Was there a cutoff date? Exactly what happened? I don't know. But what I do know is that the whole court system and prison system has been privatized. It's run by corporations. It's what we call fascism. I mean, if you go back to Rousseau movie he put out, Freedom to Fascism. I mean, people should go back and watch that if they haven't seen it. I think it's on the internet. I think you can find it on the internet. But what Rousseau was pointing out was that we have turned it into a complete fascist state, and it's ruled by corporations. And so that's why they kicked me out of the federal court building, because I was trespassing on private property, and they just didn't like that. So anyway, all these weird things happen that indicate the true nature about what's actually going on in this particular system. Now, I think it was Supreme Court Justice Rehnquist who said that 100% of the people who are in prison volunteered to be there. So how in the world did they get into those contracts where they volunteered to go to prison? Well, we'll go into that a little bit. But I want to go back again to a conversation about the statutes and codes, the penal sums, and all those kinds of things, because this goes right along with what Rehnquist said, and that is that the statutes and codes are not bonded. And so they have to have a bond. in order to move forward with their statutes and codes. And I'll give you a perfect example of it. Years ago, back in the 90s, some might remember what was called the Montana Freemen. Now, the Freemen were an interesting group. And that was, they understood negotiable instruments very, very well. And they were starting to execute upon some of that knowledge in regards to negotiable instruments. Kind of got the government a little bit upset because they don't want the people to use those instruments, and so they were prosecuted. And in consequence of that, when they had some of the preliminary hearings, the defense attorney for the Freeman was a former federal prosecutor. So he knew the ropes. He knew exactly what was going on. And so he called the prosecutor to the stand to ask some questions. So one of the questions he asked the prosecutor was, are these charges against the defendants bonded? See, because if it was actually a statute that had come and been properly enacted by the U.S. Congress, it would already be bonded by the voice of we the people, okay? So this defense attorney knew the score, so he asked the prosecutor, are these charges against my clients bonded? And he said, yes. He said, for how much? He said, $10 million. And so the next question he asked him was, on the day those charges were bonded, where were you? He said, the Vatican. He says, was there anyone else with you at that time? He said, yes, the judge. So the judge and the prosecutor had gone to the Vatican to get a bond of $10 million for the charges that were leveled against these negotiable instrument experts. So the thing went on and on from there. And so in essence then, when you start talking about the $250,000 penal sum in regards to these federal statutes and so forth, they had to bond those in order to proceed forward because the statutes themselves are not bonded. In other words, the voice of the, typically with your properly enacted statutes, they come out in what's called the statutes at large, and they're published so that people can look and say what their responsibilities are in regards to these matters. But the what's called the United States Code is not law. It never has been. Matter of fact, if you look in the very first volume, it'll tell you right straight out that all these codes and everything are pure fiction. That's why Rehnquist said that everybody in prison is there because they volunteered to be there, because you volunteer by the way you act in the court to bond their statutes, you see. And so again, we're playing with money here. As for myself, when I began studying all of these commercial things, the first thing that was recommended to me was to study negotiable instruments. So when I took the study up, actually I sent away for a correspondence course from a college on negotiable instruments. And I studied and studied and studied that until I thought I had a pretty good idea about negotiable instruments. Not that I'm an expert, certainly, but at the very least, I thought that I had a fundamental knowledge of negotiable instruments. Now that served me very well, very, very well, because when I look at a typical complaint or an indictment or a traffic ticket or whatever, what do I see? I see a negotiable instrument. And I know that when I see those things, we're not talking about crimes, we're talking about money. And these private corporations masquerading as public courts are there simply to gather all of the money that they can for their business. And they did a darn good job of it, I'll have to say that. Now, It's been some years ago. Wow. Yeah, it's come to think of it now. Wow, it's probably been over 10 years ago. Anyway, I was working with a fellow. I had an association with a fellow. He was an investment banker, and he was taking a law course so he could get a federal bar card. He thought that would help him in his business. So we had some interesting conversations. And one of the conversations, he said that he was being mentored by a retired state judge. Okay. And so one of the questions he asked him as a investment banker was, how do you monetize all these civil judgments? And the judge told him, he said, well, he said about half of the judges know how to do that. He says the other half don't. He said, as it turns out, I'm one of those that do know how to monetize them. So I'm thinking, oh yeah, negotiable instruments, So anyway, I think I've pretty well discovered a few of the methods, not all of them certainly, because again, you can't get in an audit. But anyway, I think I have discovered, several of the methods that the court system is using to make money on complaints, indictments, hearsays, traffic tickets, whatever. And so maybe I'll describe some of those things right here if you like me to.
Yeah, I'd like to get a little more clarification about
Sure.
what you were speaking earlier about the how the judge and the what'd you say, the district attorney or prosecutor, right, went to the Vatican to get the bonds.
Correct.
What's the relevance of that? Why do they have to go to the Vatican to get the bonds? I'm assuming not all judges go to the Vatican to get bonds. Why? What's the connection there?
Again, the statutes that they were charging the freedmen on were based upon the $250,000 penal sum. Now, the proof that the federal court system, in that instance, had demonstrated the proof that they're a corporation was they had to go and get outside bonding, because a corporation cannot hold asset. The only thing they can hold is debt. And in consequence of that, the statutes certainly were not self-bonding. And so in order to prosecute on those charges, they had to get outside bonding, and that's why they went to the Vatican. Others go to big insurance companies. For instance, I was dealing with some state indictments down in Las Vegas, and we managed to get into the records there with the office of the clerk of the court, and they had the insurance policies on those indictments right there in the file. I can't remember. I think it was an insurance company back in Pennsylvania. But all of these corporate courts have to have outside bonding. They cannot be self-bonding, which again proves that they're corporations and they're not operating on law. They're operating in fiction. But they're doing a darn good job of it. I mean, they got the wool pulled over most everybody's eyes. And so what we're doing today is exposing a little bit of that, get people thinking a little bit, and see if we can't encourage people to help to make a few changes. See, one of the things that's been worked on for the last number of years certainly is the correction of the financial matrix. And I think that's pretty well in hand now. But in conjunction with the correction of the financial matrix on the planet, we have to correct the justice system. Now, if you want to go esoteric just a little bit here, metaphysical, we understand that Saint Germain is in fact the main mover, if I can use that word, in the correction of the financial system. And I think there could be a lot of good stories, incidences, so forth told about that. However, his twin flame is the one known as Lady Portia. Now, Lady Portia would be best understood by that statute, of the lady who's got the blindfold around her eyes and holding the balances and got the sword there. That's Lady Portia. And so the operation that she's been working on has to do with the correction of the justice system, which is ancillary to the correction of the financial matrix. So that's being worked on levels up here, and then we got guys like you and me down here, and we're working on these kind of things down here. So hopefully these two things come together at some point. But a lot of those things are being worked on. The exposure that's being made of the system, the corporations that are running the courts and all those kind of things, and the theft of the equity and the real assets of the people in the United States, or all over the planet for that matter. Anyway, the theft by the court system of the real assets of the people has to be stopped. When we start to talk about the opportunity to create prosperity, then it's necessary to stop the theft of the real assets of the people. And on the one hand, you got the bankers over here, stealing everything they can. And then on the other hand, over here, you have the court system that's stealing everything they can. And so certainly with both sides of the equation here, we're trying to get some of these things fixed. And so that's part of the education system. First off, we have to study and find out what's really going on. And then we have to expose. We have to expose the theft and the fraud, because that's exactly what it is. Even though the banks are chartered to do certain things, the courts aren't. They never were. And these these private corporations are trying to mimic, in many instances, the bankers, and who are chartered to do certain things. But now all of a sudden you have the court system that's trying to do the same thing the banks are, and they're certainly not chartered to do that. Those private corporations on Dun and Bradstreet are not chartered to do any of that kind of thing. Yet they're trying to accomplish it with their various methods. And by using those techniques and so forth, they're simply stealing the people blind. They're simply stealing the people blind, all the way from traffic court right up to your highest federal courts. It has to come to an end. How can you see? Everybody likes to use the word justice, as if that's some kind of a holy word and so forth. But there is no justice when you're dealing with phony, fake, fiat money. You can't get justice that way. And just like Martin Luther, when he protested the paid indulgences, he says, how is that God's way? See, well, Luther had a point there. And so we're suffering with the exact same things that Martin Luther was trying to protest way back when he did his nailing up his thesis there on the door of the church and so forth. Now here we are back in 2015 faced with the same problems. And so we're trying to expose, using the internet and different things, the difficulties that we're faced with. Does that kind of help a little bit?
Yeah. To go a little further into that, you were saying how everyone in prison has volunteered or agreed to go to prison.
Right.
So what is because of the way they behaved in court, so what is the proper way to behave in court so that you're not agreeing to be in prison? Okay.
A real good book for people to read right off the top. It's a book by a man named George Mercier, Mercier, and the book is called Invisible Contracts. You can find that book on the internet. I mean, you can download it as a PDF for free. It's not going to cost you anything. Mercier was not an attorney. He was not a judge, but I think he worked as a court clerk in the New York State system. And wow, just go read his book, and then you can start to understand this business about invisible contracts and how we get into them. Again, using our admiralty system technology, most of the people volunteer into these contracts by acquiescence. Now, there's other techniques that you get into it too, and I'll discuss those a little bit further. But what Rehnquist was talking about was acquiescing to contracts. And if they can't get you to acquiesce to them, they'll try to force you into them and basically say, either sign that contract or we'll throw you in jail. And so they do that kind of thing. For instance, I was working with a fellow. He was in prison He served out his term, and so he was ready to come out. So I went to pick him up. I mean, I've been visiting him for for a couple of years there. He's a real smart fella. Real smart fella. He learned a lot. He had a lot of free time to study. So he was quite educated on certain points. So I would go visit him and spend the weekend with him at learning. Anyway, so his term was finally up, and so he was ready to get out. So I went to pick him up. I was going to haul him away to where he wanted to go. And so they brought him to the front turnstiles. They had all his papers and whatever possessions the prisoner might have in some boxes. So they passed the boxes over. So I put them, put them in my pickup truck. Then they were trying to get him to sign a parole contract. And he said, I'm not signing any more contracts with you people. He said, first off, you're dishonest, you're dishonorable. He said, I'm not signing any contracts with you. And they said, if you don't sign these contracts, we're not going to let you out of here. Well, he just took his hands and put his hands behind his back and said, I'm not signing any contracts. And so eventually they let him out. And so I said, hey, jump in the truck here. Let's get the heck out of here before they change your mind. Well, exactly. That parole contract was voluntarily. He did not have to sign that. He knew it. Now, what happened eventually, they tried to jam him up for it and haul him back to Chicago, which is another long story in and of itself. But anyway, he prevailed. He prevailed again on the basis that he had not signed any contracts. Now, if you look at a typical federal situation, it's actually a 3-contract system. And that is they have pre-trial services contracts. And then they have the actual court case, which is a contract. And then they have a parole contract. And so before people get very far along, they've already signed on to 3 contracts. And so, of course, it's done by, for the most part, it's done by lack of knowledge, but sometimes they force them to it. They'll say, if you don't sign this contract, we're going to throw you in jail. And they do. They throw them in, and turn the air conditioning way up, and play loud music, won't feed them, and do all kinds of things to torture them. So they'll sign those contracts. But if you hold out, they have to let go of you. For instance, one lady I was talking to one time, and I'm really sorry that she capitulated. But anyway, they went and picked her up on some crazy charge, arrested her and hauled her off. And I told her, I said, when you get into it with them, I said, just tell them I'm not contracting with you. I'm not going to contract with you. And so she did. She held out pretty good for about 2 days there. And then some of her friends said, hey, man, if you don't come out of jail, blah, blah, this and blah, blah, that, And so finally she capitulated. If she'd have maintained her position, which was, I'm not contracting with you, I'm not signing any of your documents, they could not have held her past 72 hours. And so we keep running into these things. If they can't get you to contract voluntarily, they put the thumb screws on you. Put the thumb screws on you and try to get you into such a position so that you will. Or they might say, well, if you don't sign these contracts, we're going to go out here and charge your wife. We're going to go out here and charge your children up for the same charges. Or we're going to do this, we're going to do that. And so people, they're nothing but a bunch of crooks. They're nothing but a bunch of mafia criminals, and that's all they are. Hey, and if any of you listening out there and you think I'm liable than you, please sue me. I'd be more than happy. I'd be more than happy. But anyway, does that kind of put an answer to your question there?
Yeah. So if a particular person gets charged with anything, if they just simply refuse to sign any contracts, then they have to release them.
Yeah, I think not only just signing contracts, but verbally denying them. For instance, this lady says, I'm not contracting with you. I'm not contracting with you. That kind of thing. So it's not only it's not only the fact that you don't sign anything, but it's telling them so that you're not acquiescing by silence. Because again, in our present admiralty system, silence is not golden, but in the admiralty, failure to respond is fatal. And so not only you refusing to sign contracts, but also telling them verbally, I'm not contracting with you. See, it was kind of funny one time I was helping the fellow, and he went into court on the pretrial services hearing, and we had the thing locked up pretty good. I mean, we had them pretty. First off, let me say, you can't beat these people in their own court, but you can get into a Mexican standoff. And so you can put them into a situation that they're not going forward and you're not going to go forward. So basically the thing dies away, and I can give you another example of that in a minute. But in any event, so I think we had the thing pretty well blocked up so they couldn't move forward. But he had signed pretrial services contracts. And so they had a pretrial services hearing to demonstrate that he was in breach of contract. Now, let me explain to you about the admiralty. There's only two reasons why someone would be sanctioned in the admiralty or put in jail, as you say. Number one is contempt of court. And we'll talk about contempt here in just a minute. But the other reason that a admiralty court could put you in jail is for breach of contract. In essence, this particular hearing was a breach of contract hearing. They brought him in, and certain words were, I was there listening to all this foolishness. So they were jabbering back and forth about this, that, and the other. And then finally the prosecutor said, well, I think we need to put this guy in jail. He's a flight risk. See? And so the judge, he said, okay, yeah. So they hauled him away. And he was in prison on breach of contract on the pretrial services contract because he had never been to trial. It wasn't even going that far. We had it locked up, so he wasn't going to trial. So again, the reason why he was jailed was based on pretrial services contract. And then after the hearing was over with, one of the attorneys met me out in the hall. Now get this now. I mean, I stand 6'2". You know, at that time I probably weighed 220 or 30 pounds. This guy was big. I mean, I think he'd played basketball from one of the universities there, so he's about 6'5", 6'6". Probably had me by a good 50 or 60 pounds. So he's trying to intimidate me. He got right in my face. Blah, blah this and blah, blah that. And yakety yak, yakety yak, yakety. See, he was trying to get me into a controversy. So I wouldn't do it. And finally I looked at him and said, I'm not contracting with you. Get out of my face. He just turned and walked away. Because, see, he couldn't get me into a contract. He couldn't get me into a controversy. So he just, having failed at that, he simply walked away. Now, if I'd have gotten into it with him, he very well could have called the bailiff out and had me arrested. Because sometimes they do that. But in any event, again, going back to the acquiescence by your silence, creating a contract, or by your signature on the document, that also creates a contract. Again, I would advise people to go on the internet, get a copy of Invisible Contracts, and study through that. And I think you'll see all these points.
So how do you respond to a process server? Let's say a process server serves some kind of legal document. Are you entering into a contract upon receipt of that document, regardless of whether you willingly accept it?
Well, it depends on you. If you want to participate in it, there's money to be made. I say that jokingly, but if you don't want to participate in it, if you accept the service, then return it within 72 hours. The typical language you would put on there would be something like refuse for cause without dishonor, so forth, and just send it back where it came. Like, for instance, I got sued one time in conjunction with 7 or 8 other defendants on a civil matter. I didn't have time to fool with it. I mean, I had other things more important, I thought, than fool with that silly thing. And so I just took, when the process server served me, I just wrote refuse for cause without dishonor, and I wrote it on every single page. And I took it right back and gave it to the clerk. Well, the court case kept going and going and going, this, that, and the other. And then when the court case was over with, 7 individuals were found guilty except for me because I was not part of that contract. So if you don't want to participate in your contracts, then you can always refuse them for cause, from the process server, return it back to the clerk of the court in that particular situation. Or if you think you do want to participate and you have a little bit of skill in some of these areas, there's money to be made. Put it that way.
Can you elaborate on that? What do you mean there's money to be made? What are the mechanics of that?
I used to know a fella. He used to go to the mailbox every day hoping somebody sued him. because he knew there was money there. Yeah, if you develop the skill and some of the things that that I've shown, there is a great deal of money to be made using counterclaim technology. And I really don't have time to explain all that, but to answer your question about what to do if a process server brings you that, it depends on what you want to do and your level of skill. And so if you don't want to participate, then go ahead and refuse it, send it back to the clerk within 72 hours of service. And then in that manner, it falls under Regulation Z, Truth in Lending. And so if you do it that way, then it cannot move forward. Although I have heard of cases where they did try to move forward, which creates what's known as a tort, which is an injury outside of a contract, and then again you're into suing, a suit for tort. Again, we're getting into areas here that involve technology, which most of the people listening probably are not aware of. So we probably ought not go too deep into some of that. But in answer to your question, that's how I would answer it.
And these are all things that you teach in your DVDs and classes?
Oh, yeah. Uh-huh. Yeah, let me give you a list of some of the DVD presentations I have made over the years. It seems like every time we do a seminar, some of this court stuff is going to come up. So anyway, if you go to the website and look at some of the DVDs, there's a single topic on civil court, one on criminal court, and one of our favorites, how to handle traffic tickets. That's always fun. Third-party debt collectors. That's really a blast. And then there's another one I presented, which is more of it had to do with absence of law. It is the remedy. And we go into the business that these statutes are not enacted by your legislatures, so forth. And so what we would do in that case, we would do a subpoena to the Attorney General and have him come in under oath and swear that the statute in question that you're being charged with was properly enacted by the Congress or the state legislature, which of course they can't do and won't do. So all that demonstrates is that the statutes are based on fiction and fraud. And then recently, for the amusement of many, I actually wrote a book. It's called Uncommon Sense in the Courts. And in that book, I simply go back over a lot of the stories about what I've done in court or what I've helped other people do in court from a kind of a practical. It's not technical, but it's little things that we've done. For instance, I'll give you an example of it. At one point, a lady from Canada called me. She's from British Columbia, and seems like she had been married to an attorney. What was she thinking? Anyway, so they split up, and he proceeded to take all of her assets that she'd had. He took her horses, her harp, all of her possessions, and when she threw a fit about it, he went to the locals and had her arrested for assault and battery. So now she got criminal charges, and so she didn't know how to handle them. So she got started in the thing, and then finally she called me up. So she was kind of deep into it before she ever called me. But I said, look, do this. And so I put her into trust law technology in this particular instance. I said, look, number one, I said, take that indictment. I said, do your acceptance for value on it. Now, this might be technology some of your audience might not understand, but that's one of the things I said, take the indictment, which again is a negotiable instrument, do your acceptance for value on it, put all that language on there. And I said, then number two, I said, create an invoice for all the property you've lost, for all the time you spent in jail, and for all the time you've had to spend dealing with this stupid thing. I said, create an invoice for the money and get it certified. In other words, she got her invoice notarized. I said, when you go to the court, I said, when you get a chance to talk, and I said, you don't need to be rude or anything. I said, just wait for your chance to talk. I said, you stand right up, and I said, you tell the judge that you're the settler for the defendant. Now, people don't realize, but the defendant, which is always in capital letters, is actually a trust. Okay, that trust is created by the birth certificate. So anyway, because you're the only contributor to that trust via Social Security and taxes, but because you're the only contributor to that trust, that makes you the settlor. And the trust maxim is that the express intent of the settlor is the law of the trust. Okay, so I'm setting her up here to act like the settlor. Now, also under trust law, the settlor can also be the beneficiary. All right. So I said, okay. I said, when you get down there at the court next time, I said, wait your turn. And I said, stand right up and tell the judge, you know, that you're the settlor for the defendant, and that you're nominating the judge as the trustee for the trust. And because the judge was an attorney, they could not resist that appointment of fiduciary. Okay, so she stood up, told the judge, I'm a settlor. I'm nominating you as the trustee for the defendant. And then I said, then tell him, actually as a lady judge, I said, and then tell her that you're the beneficiary for the trust. I said, at that point, hand over the accepted for value indictment and also the invoice, and then tell the trustee, how soon can you get that invoice paid? Well, that was the end of that hearing, and they never had another hearing. That's why I'm saying you can't beat these people in their own private courts, but you can put them in such a position where you get into a Mexican standoff. You get into a block. Now, she did call me after that and said, hey, here's what happened. And she said, what can I do about that invoice? And I said, we'll give them a 30, 60, and a 90-day notice. And after the 90 days is over with, that turns into an account receivable, which is a security. And she knew how to do that. Last I heard, she was still chasing down the attorney general up there in British Columbia trying to get her money. Whether she did or not, I don't know, but she could certainly take that security and turn it into some useful paper in commerce, because, again, it turned into a security. I think it was something over $3 million that she had calculated on that invoice. So you get into these things. And so, like I say, we're not talking about justice here. We're talking about commercial monopoly. I mean, we're playing a game with these people. Another kind of interesting story. A friend of mine from down in Georgia, he called me up and said, hey, I'm helping this lady with this criminal case down here. And he said, we're doing this, we're doing that, and all that kind of stuff, and he was a friend, or I wouldn't have listened to him, because I was trying to have vacation. He called me when I was on vacation. And you know how rare that gets to be. Anyway, so I'm on vacation. I said, oh, geez. Okay, I said, look. I said, next time you have that lady go down to court on one of her hearings and stuff, I said, have her take along a handful of IRS W-9 forms. And I said, as soon as she gets in there, I said, start passing them out to the judge, prosecutor, the clerk, and everybody, and see what happens. Well, people don't know what a W-9 is, so I'm not going to explain all that. But anyway, they shut that case down in a big hurry, because the W-9 would have proven that the judge and all the officers and all the employees and so forth was a part of, again, that private corporation. And they didn't want that exposure. And so they shut that thing down. And he told me that every time she came into that courthouse, as soon as she came through the turnstiles there, word got all over the courthouse, she's back. So like I say, in this particular book that I wrote called Uncommon Sense in the Courts, I go through a lot of the stories of things we've done, things I've personally been involved in, different techniques and stuff we've talked about. Really, you can't read those things in the book. You just have to go and experience them, play around with it a little bit to see what happens. And, do I always win? No, I don't always win. Do the people I help always win? No, they don't always win. But at least I'm trying to give people a good enough edge that they stand a lot better chance than if they have an attorney. Because maybe I should read to you about what an attorney is, because your audience needs to know this. And that is, this is out of one of our two basic law books, Corpus Juris Secundum. This is from Volume 7, Section 4, page 799. It says, an attorney is an officer of the court with an obligation to the courts and the public as well as to his clients, and his duty is to facilitate the administration of justice. An attorney does not hold an office of the state. An attorney does not hold an office of public trust in the constitution of statutory sense of that term, and strictly speaking, he is not an officer of the court before which he has been admitted to practice. An attorney is not the court or one of its ministerial officers or a law enforcement officer. He is, however, in a sense, an officer of the state with an obligation to the court and to the public, no less significant than his obligation to his clients. Now get this, his first duty is to the courts and the public, not to the client. And wherever the duties of the client conflict with those he owes as an officer of the court, the former must yield to the latter. Now, why it is in this world people go and get into some of these difficulties and stuff in the court and whatnot, why is it they run off and hire an attorney? I have no idea. But I guarantee you, if you get an attorney, you just hired one of them. Now, what do you think is going to happen when you do that? So people come to me all the time saying, well, I got this court case going on over here. And they want me to advise them on certain things. The first thing I ask them is, do you have an attorney? If they say yes, I say, are you going to keep that attorney? Because if you're going to keep that attorney, you're wasting your time talking to me. Because the attorney won't do what I'm fixing to tell you to do. You see what I mean? And so people need to, become educated, get some of these, and not just me. I mean, there's a lot of people who put out a lot of good information about courts and stuff, but because I know about my own products, I would suggest that you get some of these DVDs, if for no other good reason, for a good laugh. Get this book on uncommon sense in the courts, because I just wrote it as just like I'm telling it, just like I'm talking, But when you look at the various situations that I'm working with, if you understand what I'm doing, then there's a lot of technology there that could be very, very useful in a lot of different situations. So again, the people need to be educated. For those that get a chance to listen to this interview, I would suggest listening to it several times, because some of the things I've said so far are purely will cause cognitive dissonance. I know they will. But I'm telling you here from firsthand knowledge. I'm telling you here from the experiences and stuff that I've had, things I've investigated, things I've found out, and so forth. So if it causes you confusion, then listen to this interview another time. I mean, 2 or 3 times, and let some of your friends listen to it, some of those that have had experiences. I think the statistic right now is that 1 out of 6 families in the United States either has some family member that's been in prison, is going to prison. 1 out of 6 families. Don't tell me this is not affecting everybody in America, because it is. I guarantee you, everybody here, everybody listening to this interview is going to say, well, yeah, I know some so-and-so that's thrown in prison over here. What for? Again, what are they there in prison for? It's because the courts are making money at it. And when we get a chance here, when you're ready, then I'll describe some of those methods that they are using to make money off of people.
Yeah, I have a lot of questions. Well, backing up a little bit, you mentioned traffic violations. I'm curious if you can maybe tell a story or give an example of how someone actually overcame a traffic violation. I had a friend recently who got this wasn't a traffic violation, but she got a ticket for parking her car in the opposite direction on a street, which seems ludicrous to me because the car was parked properly. It just happened to be facing the direction. So how do you deal with situations like that, or a traffic violation?
Well, there's several strategies that can be used. On this particular DVD on traffic tickets, there's demonstrated about, 3 or 4 different techniques that can be used to overcome that. It's basically getting them into a position, where they have nowhere to go with it, destroying witnesses and so forth. Let me express that traffic tickets are what are called quasi-criminal. And that is, they've taken a civil issue and turned it into quasi-criminal so they could extort money. As an example, if you go to any traffic code, there'll always be some kind of jail term and penal sum attached to it. And so you get into court and the judge says, well, you're charged with, going 10 miles over the speed limit over here and so forth, and how do you plead and all that kind of stuff. And you get into a conversation and so forth. And in essence, when he gives the judgment, he says, if you don't pay it, we'll put you in jail. Now, would anybody in their right mind pay something stupid like that without the threat of jail? Well, of course not. I mean, one time I sat in traffic court on this one little town where I was living at, and the people, it's just like, herding cattle through a chute. I mean, they were going through just as fast as they could go. And so they'd get up there, the judge say, well, he said, looked like you've been speeding over here. He said, I could charge you $500 for that. He says, but I'm only going to charge you, let's see, $200. Oh, thank you, Your Honor. Instead of having to pay $500, I don't have to pay $200. Now that's extortion. Now, what he didn't read was the jail time if you didn't pay it. It might be anywhere up to 6 months in jail if you don't pay the traffic ticket. It's called quasi-criminal, which the word quasi means as if. And so there's all kinds of ways to resolve some of that. You can beat those things in court if you want to practice with it and learn how the techniques and so forth. The easiest way to resolve traffic tickets is with promissory notes, negotiable instruments. I had a friend down in Southern California one time, and this guy was good. I mean, he could beat traffic tickets if he wanted to, but he'd rather go play with them. As a matter of fact, at one point, the county attorney offered him a bar card just to get him to stop, but he wouldn't take it. He didn't want to have anything to do with that. So anyway, he's on a traffic thing down there, somewhere in Southern California, and the judge said, well, he says, you're guilty. He says it's going to be $200. And my friend said, $200? Are you sure that's enough? How about $2,000? The judge said, well, okay, $2,000 then. So he sat down there and wrote him out a promissory note and gave it to him. The judge looked at it and said, well, he says, I'll take it this time. My friend said, you'll take it every time too. Because, see, he understood the use of negotiable instruments. And had another kind of funny one too, the traffic thing. Some friend of mine was traveling down through a small town, and he had, I think the light was out on his trailer or something, so they gave him a ticket for that light being out. I think it's only like $40. He liked to play with them, so he'd go back down to court, back and forth with them. And then finally, probably about the third or fourth court appearance on a $40 traffic ticket, he finally told the judge, he said, I've come to settle up. The judge says, thank goodness. So he had a promissory note all made up, and so he gave it to the bailiff. The bailiff took it over to the prosecutor. The prosecutor looked at it and said, okay, take it to the judge. So the bailiff took it to the judge, and the judge looked at it and said, promissory note, said, we can't take this. And the prosecutor jumped up and said, oh, yes, we can. Because the prosecutor was an attorney, and the traffic judge was, I don't know, some farmer. I don't know who he was, but he didn't understand law. So, however you want to handle it. I mean, there's 50 ways to skin a cat. And so again, in this DVD, I show different ways you could beat it. Or if you just want to let the thing run out and give them a promissory note, you do that too. Whichever way you want to handle it.
Now, doesn't every judge have a special bank account that a lot of the funds that are collected in court go into?
I'm glad you mentioned that. Yeah, I was going to. How much time we got here? We still got plenty of time.
Yeah, we got time. Go ahead.
There's an article that I have here written by actually the fellow that wrote this article. I think is an Australian, But anyway, he was going through the United States Code and so forth. And if somebody would like this article, I'll be happy to make it available to them if they want to send the email to the office there. I'll have it. I'll send you out this particular. It's a real good article. I mean, I can't go over the whole thing because he quotes statute after statute after statute. But the title of the article is called "The Kickback Racket," in parentheses, bribes. What he does, he goes through the cash awards that are given to the courts and so forth. Let's see here. These are they can range anywhere from $5,000 to $25,000. They can be paid out to the judges, the attorneys, the clerk, the guy that's the janitor in the building. And where's that money come from? Well, it comes from you or whoever the prosecuting and so forth. The IRS is real famous for this. So under the statutes and so forth, the IRS can get a kickback on things that they do. And that's why, again, the judges in these private courts, these private corporations, are entitled to 30% of all the money they bring in to go into their retirement fund. Okay, now just think for a minute, why is it so impossible to win a court case? Because the judge is getting 30% of it. Why would he give that up just so he can find you innocent? You see what I mean? So if they're getting 30% into their retirement fund, isn't that a conflict of interest? Well, of course it's a conflict of interest. But could you prosecute them for conflict of interest? The answer is no. Because, again, it's a private court. Now, they are masquerading. They are masquerading as the original jurisdiction courts. So sometimes you can embarrass them on the basis that they do not want to reveal the fact that they're a private corporation masquerading as a government as a government court. So in many instances, we simply fire the judge, and they'll leave. I mean, it's really easy in civil matters, criminal not so easy. But in civil matters, we just fire the judge and tell him to get out. For instance, I had a friend up in Washington State. He got into a squabble over a civil matter with one of the judges up there. Judge wasn't acting right, and so he just told the judge, "You're fired." And the judge got up to leave, and then my friend asked the judge a question on the way out. The judge turned around at him, looked at him, and said, "Why should I answer your question? You just fired me." Then he left. He didn't answer the question. So in civil matters, it's pretty easy. When you get into some more complicated situations with criminal things and so forth, we have to take extra measures in some of those instances. And unless I give out technology that people can't really use, probably I won't mention those things. Although in some of these DVDs I had talked about there, we do bring those remedies up and so forth. But my advice, if I can give advice, my counsel to people is learn what you're doing before you go and attempt some of this stuff. I mean, just don't go, read a book or listen to one of my DVDs and just go out and try to think you're going to change the world. It ain't going to work. You got to get a little bit of experience. You got to have a little bit of gumption. You got to be brave, when you get into these things, because they can turn your world upside down if you don't know what you're doing. They can turn your world upside down. And so, the advice is to know what you're doing. Know what you're doing. I just talked to a guy on the phone this morning. He got into a situation, and he was dealing in the bankruptcy, and they had flipped a Chapter 13 into a Chapter 7, and they were trying to liquidate him. And so I had to show him certain techniques to get that stopped around. So we had to do some subpoena ducis tecum as a proof up on the B10 forms. But again, I'm talking about things probably most people never heard of before. But my point is that you need to study, you need to learn the things, you need to start somewhere, and to keep this mafia organization called the court system from stealing your money, because that's exactly what they're in place from. They're not only stealing from you, they're stealing from the whole country. I haven't even talked about how they go to the U.S. Treasury, to the federal window, and collect on these indictments and everything. But when they steal from the Treasury, they're stealing from all the people. And Treasury's letting them get away with it, which don't make me real happy. And so, but in any event, we're trying to put an end to this. Again, how can we become spiritually enlightened, when we're having to fight with these low-level criminals? I mean, if you spend all your time out here trying to deal with a stupid traffic ticket when you could be doing something else, I mean, where's that getting you? And so, again, what I've tried to do with civil and criminal situations is to help people understand the nature of them, show them the various remedies that are available and so forth, give them a little bit of encouragement so they can move forward. Because, if all the people understood, what I understand, we wouldn't have a problem with the court system. You see? Because it wouldn't take very long. There wouldn't be a private corporation, and we'd take them right out. And I just did. About a year and a half, almost 2 years ago, I made a major move. It cost them $1 trillion. That's what it cost them. And but that's me. I know I can do those kind of things, and I do them. Other people are not to that point, where they would attempt something like that. But I do that kind of thing regularly.
Do you care to share that story?
When we start to talk about again, there are certain remedies, certain techniques that are available in commerce. And so one of the remedies that I typically use has to do with moving money. Now, one of the fellows that I first learned from, I haven't known all this stuff. I had to study just like everybody else. But one of the fellows, a fellow named Hartford Van Dyke, smart fellow, he made the statement that you'll never see change until you make the money move. And so any corporation is in business to make money. If they can't make money, or if you take money away from them, then pretty soon they're going to have to implode in on themselves. And so in a particular situation, I was actually attacked by two quote unquote legal organizations on a particular issue. And so I just waited my time. I waited my time until I had enough of the situation. And then I did certain commercial processes and liquidated them jointly and severally for $1 trillion. And they decided after that they really didn't want to bug me no more. And so, again, a lot of the things you get into, you're not going to get justice. You're never going to get justice when you're dealing with money, for crying out loud. But when you get into some of these situations, you can at least, like I say, get into a Mexican standoff. If they shoot, you shoot, both of you go down. And so in a lot of cases, the best you can hope for is the standoff. And so the technology and so forth that I've worked on and developed, so forth, could in fact put you into a standoff, because again, you're not going to win.
So if the birth certificate is part of what's entering us into this contract, then what should a pregnant mother do? Should she not get a birth certificate?
Oh no, get one. Without the birth certificate, you can't operate in commerce as people typically do. You could operate as a corporation with an EIN number, such as an employer identification number. However, with the birth certificate, the registration of the birth, that's what creates the exemption from taxation. So that's a very valuable tool. Now, when a child is born, they are delivered into the hands of a state official called a doctor. So you just gave the baby to the doctor. So it's now his now, isn't it? Anyway, they go through the process of creating what's known as an application for a live birth. They use that live birth to create, in essence, a foreign situs trust. The registration of that birth creates the exemption from taxation. In consequence of that, those documents pass through the U.S. Department of Commerce, ending up with the Depository Trust Company in New York, who creates the bonds that are necessary to guarantee the debt that you would incur during your lifetime. So that's actually a good thing to do. The only problem is that when we subrogate that benefit by signing the Social Security 5 form to set up a Social Security account. Now, we do have the ways to reverse those problems. I mean, there's several ways and several things you can do. Of most interest, perhaps, is the last technology that we developed. I think we talked about it a little bit this last interview we had. And so I recommend to people, if you go to the website, there's a single topic DVD that would be very informative and instructional to help you accomplish that reversal. It's called Reclaiming Your Status and Assets. I'm proud of it. Put it that way. I believe that if every person in the country had that knowledge and information and applied it, that would be the end of the problems. That would be the end of the problems, because it will prevent these agencies and corporations and everything from stealing your assets. Now, again, there's been a lot of talk about how do we restore prosperity to our country or to any country. And my position has always been, no, we don't need everybody with $1 million bank account. What we do need is to guarantee that whatever the people earn, they can keep and use as they see fit. Now, that will bring prosperity. I mean, back in the days when I was working for wages and so forth, the boss come along and said, well, we need overtime. And my position was, why should I do overtime when it'll all be just taken up in taxes anyway? Why should I break my back for nothing? And that's the same thing all over the country. If people know that whatever their labor produces, that 35% of it's going to be taken away and they can't use it. A lot of people think that taxes go to the government for the infrastructure and all that kind of stuff, but nothing could be further from the truth. Nothing could be further from the truth. So all this income tax scam that the IRS have been running, that your state government's been running, all that kind of stuff, none of that money comes back. It's gone. And if they want a new road, if they want a new school, if they want a new hospital, they issue bonds, which is further indebting the public. And so all this money, I mean, years ago, I used to go back and forth from the west to the east on Highway 70, Interstate 70, right across, I think it was Kansas. And there was a toll booth on a certain section of that interstate. And I remember very well from 1970. And I went back on that same route probably maybe 2 years ago, and the same toll booth was still sitting there. Now you're trying to tell me that in 40 years they hadn't paid for that section of highway? Where's the money going? Where's the money going? See, so somebody's ripping it off. Somebody's ripping off all those tolls. It's the same thing all through the country with all these taxes and all this kind of stuff. They're ripping you off, and you're getting nothing for it. You're getting nothing for it. So there need to be changes made, and so that's the only way that we're going to ever have any kind of prosperity in the country, if we stop bleeding away our assets to a bunch of criminals and crooks. In particular, the conversation today has been about the court system. We could just as well be talking about the banking system. We could be talking about the insurance system. We could be talking about all these things that we have in our economy and so forth that are simply bleeding the people to death.
So you mentioned that getting the birth certificate is a good thing. So if a child is born into the world, and for example, let's say the parents don't want to vaccinate, or they don't want to, because nowadays we seem like we're heading toward forced vaccination. At least it's required. It's going to be required in California soon. And how do you prevent your child from being taken away from you in that process?
Yeah, that's the subject matter of that particular DVD, Reclaiming Your Status and Assets. Now that could be implemented, which would give you complete control over the body of the child. In essence, what we're doing with that technology is we're creating an ownership document of the body, because it's the body that's in question. It's not the straw man, it's not the fiction or anything. They're actually going to stick mercury and all kinds of crap into your child. So the question is about the body, who has control of the body. So in essence, what we're doing here is we're creating an ownership document of the body, and then getting the status of the fiction changed. Now, as an example of that, when I first developed that technology, or when I was first working on it, I had an opportunity to speak to one of the ladies. She was actually married to one of the Sioux chiefs up in the Dakotas. And we were discussing this very problem, whereas the federal government were coming in simply stealing the children off the reservation and taking them to God only knows where. And I said, I think we put a stop to that. And so I showed her this technology of creating the ownership document for the body. And then I said, I think you can, not only can you prevent them stealing or having anything to do with the body of that child, inoculations or whatever. I said, I think with a little bit of legal work, you can go back and get back, some of the children that have been stolen. And so again, we're going, with this technology, we're going on to the private side, and we're dealing with real estate. It's kind of interesting. Do you recall a movie years ago? It was called The Amistad.
Rings a bell, but I don't remember seeing it.
Yeah. Well, what that was, it was some, I think it was Portuguese or Spanish slave ships had picked up some African people and were transporting them, I guess, to the Caribbean or someplace, and they had mutiny, taken over the ship, and then the U.S. government picked them up or something happened. Anyway, so they were having this great big trial, about who owned these slaves or who owned these African people and all this kind of stuff. The guy that solved the problem? It was a real estate attorney. Now, isn't that interesting? With all this question about slavery and who owned this and what treaties and all these kind of things, eventually it was a real estate attorney that came forth and solved the problem. So when we're talking about some of these situations about inoculations or stealing children or whatever it is they're doing, look at it from the perspective of real estate. And so on this particular DVD, I show you how to create the ownership document for the real estate. And then we do other things in conjunction with that to create perfected security interest under the Uniform Commercial Code and some of those other things. So it's if you don't have any experience at all with some of these technologies, it might be just a little bit difficult at first. That's why when people get that DVD, I always tell them, I said, look, sit down and watch it once, all the way through, just to watch it. So then go back the second time, take notes. Then go back the third time. Now, however many times it takes to get these things fixed in your mind, because again, I have a lot of experience. I've been at this now for over 17 years. I mean, by this time I got a PhD in this goofy stuff. Okay, and so a lot of these things are very easy to understand for me, but for someone that has just a little bit of experience or no experience, so forth, it takes just a little while. So again, I never encourage people to do anything they don't understand, unless if your back's against the wall, you can do whatever you need to do. But anyway, for the most part, I think that people would be well served to spend a little time on some of these subjects. Like I say, today our subject matter has been about the court system and some of the goofy stuff that goes on there. And who would ever imagined? Well, I imagined it because I've been down there fooling with these people. But anyway, for some of those who might listen to this interview and so forth, it would be good, to dig in a little bit and, get a little bit of information, get some material. There's a lot of free information out running around. Like I say, that Mercier book, Invisible Contracts, that's you can get that downloaded right off the internet. If you understand all of that, you're going to understand a whole lot, because Mercier was really a smart fellow. And then, like I say, there's a lot of information running around, not just from me, but from plenty of people. And so you don't have to take just my word for stuff. I study everybody. When I hear about something, I go check it out. Find out, what does this guy know? What does this lady over here talking about, and so forth. So it's important to get well-rounded. I mean, I do not want any Winston clones. I do not want any of those. For instance, I had a guy come up one time. I'd done a seminar years and years ago. I'd done a seminar down in, I think it's New Mexico. Somebody recorded it for whatever reason. And so some guy had taken that recording. He had transcribed the whole thing word for word, and he memorized it. And then he came to see me about it, And he could sit there and quote that whole seminar word for word, start to finish. And then I asked him the question, what does that mean? And he had no idea what it meant, although he could quote it, you see. And so people have to study, develop understanding, get a little bit of experience here, a little bit of experience there, talk to people that have had this or that, and try to get a little bit of focus with some of this stuff. Because, we don't, I always say that one small success is worth 100 big failures. And so I always encourage people to start small, with whatever knowledge you have. And then if you think you get to the point where you can handle some of these more difficult situations, then at least you've worked your way up to it. You understand what I know you understand what I mean with that.
No, I think I interrupted you a while back with all my questions. Was there more that you wanted to share on the court system today?
Well, I was going to go over a little bit. Oh, and by the way, we're going to have I got invited to speak on a sea cruise. Me. Anyway, I think they're putting together something called Conspiracy Cruise, and there'll be several speakers there. I'll be one of them. I think Carrie Cassidy is going to speak, Laura Eisenhower, John David Morton, and a whole host of people on this cruise. And the subject I'm going to bring up is, number one, this business with the courts, to show people the various remedies and different things could be dealt with there. I'll also be speaking about mortgages, real estate, conspiracy with all those kind of things and so forth. And then every day that we're actually on the water, I understand there'll be courses being offered, lectures being offered all day long. So people can pick what it is they want. If you go on the website, it's going to be the end of January, which would be a real good time to cruise down to Baja, California. It'd be warm anyway. But anyway, for those that might be interested in that, I'm putting this advertisement in, not to be too commercial and whatnot, but it should be pretty good thing for people to be involved in. And of course, I'll be there live in person. You can shake my hand, or get me to autograph a book or something, and all those kind of things. But that's if you go to the website, it's being advertised there. Now, as I mentioned, the first thing that I'll be speaking of on that cruise is the subject matter we're having today, and certainly some of the issues and items in regards to the way the court is stealing your money. Well, I just wanted to mention, I had mentioned the situation with the Montana Freedman situation, and that was really an interesting situation to follow. They were found innocent on the initial charges on the negotiable instrument, but then they wouldn't rearrested them, charged them up with the IRS crap. And that's what they were really convicted on, was some of this IRS stuff. But anyway, as you look at, I had mentioned that the statutes, the state statutes, the penal sum on them is $100,000. The federal statutes $250,000 as far as the penal sum. If you have the money, you can just simply go pay it off or make other arrangements. For instance, I told the story about the fellow from Florida that had the 5 charges for a grand total of $1.25 million. And I told him, hey, just go give the prosecutor a promissory note. And he didn't. He went to jail. And so we get into some of these situations. Now, as I mentioned, on any criminal matter, there's actually 3 contracts that you have to deal with. If you start to deal with them in certain manners, then you have to deal with all 3 contracts. In other words, you got the pretrial services contract that one fellow went to jail on the pretrial services contract as a flight risk. And then the other contract is actually the court. Now, in a typical court situation, criminal situation, it actually has two parts to it. The one part is the magistrate, which is the civil portion of it. And then if the magistrate decides that it cannot be settled civilly, then it goes into criminal. And so that's why they're always asking, do you plead, guilty or not guilty or whatever? A lot of people are mistaken totally. Remember, this is not a court of justice. This is a commercial court. Now, what people don't understand is that a not guilty plea is a commercial dishonor. When you say not guilty, what you're telling the magistrate is I'm not going to pay for this negotiable instrument. See, again, as I mentioned, the indictment is a negotiable instrument in the form of a bill of exchange. The only question is who's going to pay it? And so the magistrate hauls you in. When he says, how do you plead? What he's actually saying is, how are you going to pay for this bill of exchange? That's what he's really asking. And if you say not guilty, what you're saying is, I'm not paying that. That's a commercial dishonor on the basis that we are operating a Chapter 11 bankruptcy in this country. That's why it's a commercial dishonor. That would probably take me a full hour to explain why that is, but I'm just saying for people's amusement, as it were, that a not guilty plea is inappropriate in a commercial court. The appropriate plea in a commercial court, again, due to the Chapter 11 bankruptcy, is guilty. Now, guilty to what? So we would typically say, well, I'm pleading guilty to the facts. What are the facts? Well, so far there aren't any facts now, are there? You see? And so you have to set these things up, when you start talking about how to make pleas and so forth. But my point again is when that indictment hits the court, it's signed by an attorney. It's signed by an attorney based on a true bill that came from a grand jury, all of which is illegal. In any event, a bill of exchange is created, is presented to the clerk of the bank. Oh, did I say bank? Oh, I meant court. But it is a bank. All right, so the attorney signs a bill of exchange, gives it to the clerk of the court, and at that point, the court becomes a third-party debt collector. So the question is who's going to pay for this bill of exchange? So they drag you in there because you're the surety for the defendant. And so they talk to you and say, hey, you're the trustee for this trust over here for this defendant. So just how is it you're going to pay for this bill of exchange? That's exactly what's happening. Now, the question gets to be, what happens to that bill of exchange? Okay, going again back to 1933, we mentioned this earlier. And if you look at House Joint Resolution 192 of that date and all the subsequent things that happened to that, the United States government is responsible or liable for all the debts of the U.S. citizens. So they have what's called the federal window at Treasury, where a debt of a U.S. citizen can be presented for payment. So when that indictment comes in, the judge locks it up in his vault because he knows good and well it's money. So he locks it up, then they make the arrangements through certain mechanisms I can discuss here perhaps to make presentation at the federal window of the U.S. Treasury, and they would do an electronic funds transfer into the bank account of the court. That's how they get the thing paid. But then they have the audacity to come back and want a double payment on it from the defendant. See, they're double dipping. And then if they really get inventive, they might even triple dip. And the way they triple dip is called the GSA bonds. These are Miller Act bonds. That's kind of a long story. But anyway, the Miller Act bonds, and there's, I've got articles on this too if people are interested in it, about the prisoner bonding system and so forth. But if the defendant or the surety for the defendant comes into court and makes a not guilty plea, they will issue the GSA bonds, which they hope to sell on the international. So now we were triple dipping. You see what I mean? These guys have set up this crazy program here simply to make money, and then if they can get you into prison, guess what? They make money on the prison system too. They just keep trading and trading and trading. Again, go down to Dun & Bradstreet and check out the name down there, and you'll find out they're trading as whatever corporation. See? So this whole justice, what we think is the justice system, is simply a money-making operation. That's all that it is. Well, go down to the federal courthouse or go down to your state courthouse to look around. How do they afford to build that building? I mean, you go into some of these places, man, they got walnut paneling, they got all this marble tile. I mean, for crying out loud, the toilet paper holders are gold plated. Where'd they get that money from to build that building? I got no idea. I mean, I couldn't afford anything. I wished I lived in someplace nice as that. You know what I mean? So how do they do that? I mean, it's not coming from the taxpayers. The tax money is going somewhere else entirely. So where in the heck are they getting that money from? See what I mean? And so that's why I say it's nothing but a mafia scam operation, and that's all they've done. They've enslaved the American people under the idea that the people are going to court for justice, when in fact they're not. They're going to court to get ripped off, and that's all that's happening. And I have nothing but disrespect for those that are doing it, because you know you're doing it. There's no way out of this. And so you have to be replaced. And if Lady Portia has her way, there are going to be a lot of replacements, and I think not in the too distant future. Yeah, the whole thing's changing. Once the exposure is there and so forth, then we can start to move forward with some of those changes. I do know that the judges at the very highest levels have been under sequester for at least a couple of years that I know of. I did. It's kind of funny. The fellow I met knew he had some criminal charges up in Salt Lake City, Utah. And when he got up there on these criminal charges, the judge told him, he says, you're going to have to go out and get your own attorney. He says, we can't afford to give you a public defender because of Winston Shrout. He said that in open court. Can you believe that? And so we see the same thing going on at certain levels. And like I say, you won't see change until you make money move. And trust me, I know how to make money move. And so about the only way you can do with a corporation to get rid of, bankrupt the corporation, and then all of a sudden they find other things to do. And so it would be hopeful. I know in the country now there's a great movement for common law court systems. There's a lot of movement among the people to establish common law grand juries. And so the people are waking up. The people are waking up to this, and they're saying, hey, no more of this crap. We can't take any more of this. And so the people are starting to take matters into their own hands, and I applaud them for doing so. And so together, together we'll make this thing work. We'll get these changes made, and we'll go on to a much better country when we get these things taken care of. But, it's kind of interesting here about, a couple of months ago, I was approached by a couple of fellows, one of whom was a judge. Now get this. This fellow he'd been on the bench 17 years. He worked in the family court, and he was an honorable fellow. I mean, I really liked him. He was a family man. He had children of his own. He took care of his family. He was a church-going man, and as far as I could tell, a completely honest individual. Well, as a sitting judge in the family court, he had discovered that somebody was dipping into the till. In other words, the money that was designated for the use in that system and so forth was being stolen. And so he started to investigate it. And as a result of his investigation, he got charged. Somebody got wind of what he was doing and did not want the exposure, so to stop him, they charged him up criminally, which is one thing. But then he, I had the opportunity. He came to me and said, what do you know about all this kind of stuff? So I started explaining to him how the system really worked, and he was completely shocked. He had absolutely no idea that's the way things work. But as I pointed out certain things to him, he could start to see it. And so not everybody in that system, would be considered to be criminally minded or anything like that. Many of the people that work in that system are honest, hardworking people and do the very best they can. Those kind of people we need to keep. We need to keep those people in place. But for some of the others, that are doing some of these misdeeds and stuff, they have to go. We cannot keep them in the justice system because they don't have the slightest idea what justice is. And so those things are being changed. We're working on them. And a lot of people are working on it. Like I say, this common law group, like I say, there's over the countryside, there's a lot of people standing right up and saying, no, we ain't going to put up with this. I was watching, about a year ago, it's kind of funny. I was watching a YouTube presentation from over there. I think it was in England. And the people finally had enough of it. And they went in and arrested the magistrate and hauled him out of court. And the constables and stuff was right there. And so when the people told the constable what they were doing, they agreed with him. So they hauled this judge out of court because he had no bond. And so they hauled him out of there. I don't know what they did with him. But anyway, the people are waking up. And they're saying, no more. We're not having any more of this. And so eventually we'll get to the point where we have a fair and a just legal system. It's going to take just a little bit of work, going to take a little bit of time. We're going to have a hard time finding people with enough knowledge that they can carry on this system who are fair and honest. So, but we're working at it. We'll get it done.
Last time we talked, you mentioned that that there were changes taking place within the U.S. government and that there was an interim government in place. Any progress on that you know of?
I don't know what opposition you're running into. We expected, even Keith expected, that they would announce the new currency last October the 22nd and 23rd. When it didn't happen, we were surprised by it. But the announcement of the new currency will probably be the main announcement. And then, so we got our fingers crossed that they'll hurry and get it done. Like I say, I don't know what kind of opposition they're running into that's causing the delay. But from my observation, all the information I have, that it's completely in place, completely functional. The Pope Francis came. What was that? That was in anyway. What a lot of people didn't know before Francis came, about 2 weeks before he came, they disincorporated the Washington D.C. There's 3 city-states that we've had the problems with: Washington, D.C., City of London, and Vatican. It's kind of interesting that Francis does not live at the Vatican. He lives out in town. He goes to the Vatican to do business. But anyway, about 2 weeks before he got to the United States to address Congress and the United Nations, Washington, D.C. was disbanded and put under the jurisdiction of Virginia State. Now, that's very, very significant. And so what the implications of that all are, I really can't say, but I certainly sat up and take notice when that happened. And then, like I say, we were hoping that the new currency would be announced. Like I say, as far as I know, everything's in place, and I don't know what the roadblock is they're having to fight with now. Maybe it's the Pentagon, or I don't know who it is that's causing the problems, but those problems will be overcome. And so I have full confidence in this changeover.
This is the first I'm hearing about that. Where can we go to find out more about the disincorporation?
It was in the newspaper. It's kind of funny. I think maybe the reason it was in the newspaper was Maryland. The 10 square miles or whatever it is of Washington, D.C., a lot of that original land came from the state of Virginia, and then some of it came from Maryland. And so when they disincorporated, put the whole thing back under the jurisdiction of Virginia, then Maryland come along and said, hey, wait a minute, that part of that's ours. So they were fighting over it, trying to get back, the portion that they had donated back in, back in the 1800s and stuff. So that more than anything else, that's what hit the newspaper. But you can go back probably, I forgot what newspaper it was, but it was back during that period of time. You can find those things. And there, like I say, there's a lot of people commenting on it on the internet and so forth.
That's obviously very significant. When was DC originally incorporated?
1871. In 1871, after the Civil War, there were actually, as I understood it, either 3 or 5 separate jurisdictions within that area, and then they combined them into one, which we now call the federal government, which eventually evolved into what we just got rid of, which is the United States Incorporated, a maritime corporation out of Puerto Rico. And so, 1871 was a significant date. And then it seemed like they disincorporated that corporation in 1978. And I'm not really sure of all the little intricacies involved with what we have today, but to answer your question, is 1871.
I see. Well, it's very interesting. Obviously, there's some kind of movement happening, and it'll be very interesting to see where it all leads. So, well, thank you for joining me today. I'm looking forward to having you out here in Michigan at our expo this March.
Yeah, we're looking forward to it.
Yeah. So I'm sure we'll talk again soon. We'll touch base every once in a while and see what things are developing. But thank you again for taking time today, and we'll talk soon.
Well, thank you for what you do, Ethan. You're doing great work.
Thank you. I hope you enjoyed this episode of Awake and Empower TV with my special guest, Winston Shrout. Join me next week as we speak with another incredible individual who's standing on the leading edge and changing the world.